5 seconds to go. Start. However, the High Court held that since these documents were available in the case diary, they could be exhibited under Section 91 CRPC. Accepting the plea of the prosecution and the appellant, the single judge set aside the trial court's order which had dismissed the application seeking the summoning of the documents, and the trial court was directed to pass a consequential order on the application. It is, however, the other judgment of the High Court dated 8th April 2022 in miscellaneous criminal case number 57152 of 2021 mentioned earlier, which rejected the petition instituted by the appellant under section 482 challenging the order of the trial judge dated 13th November 2021 dismissing the second application, which has been called into question in these proceedings. We have heard Mr. Ramakrishnan, Senior Counsel, appearing on behalf of the appellant. Mr. Lalit, Counsel for the State of MP, had supported the submissions in the appeal. Mr. S.K., Senior Counsel, appears on behalf of the second, third and sixth respondents, while Ms. Bansuri Savraj appears on behalf of the fourth and fifth respondents. The submission, which has been urged by Mr. Ramakrishnan, Senior Counsel, on behalf of the appellant, and by Mr. Lalit, Counsel for the State of MP, are set out below. The production of the decoding register is crucial to establish the correlationship between the location of the accused and the cell phone tower. The application was filed by the prosecution before the closure of evidence, and it was only after the rejection of the application that the order dated 30th November 2022 of the second additional sessions judge recorded that the evidence of the prosecution stood closed. In any event, there was no bar in law to the filing of an application under section 311 even after the closure of evidence. The production of the decoding register was sought under the provisions of section 91 CRPC, which exists independent of section 207 CRPC, and there is no element of prejudice to the accused, since the enclosures to the supplementary charge sheet specifically refer to the certificates of the nodal officers of the cellular companies. Mr. S.K., Senior Counsel, appearing on behalf of the second, third and sixth respondents, has urged that, in view of the bar contained in section 301 CRPC, it is not open to the appellant, who is the spouse of the deceased, to pursue these proceedings. The nodal officers have already been examined on 7th May 2018, 17th July 2018 and 31st October 2019. The locations have been mentioned by the witnesses, and all relevant documents are already on record. Ms. Bansuri Savraj, Counsel, appearing on behalf of the respondents 4 and 5, submitted that 4 applications were submitted by the prosecution under section 311 CRPC. 53 witnesses have been examined. Final arguments at the trial are to be addressed on 25th July 2022. In view of the decision of this court in Swapan Kumar Chatterjee versus Central Bureau of Investigation, an application under section 311 CRPC ought not be allowed. Stop.